Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, friends, welcome back. We're here with Jeff Roberts, a Calloway County injury attorney. And Jeff, good to see you again, buddy.
Good to see you, Jim.
Absolutely. You know, I introduced you as an injury attorney, but I mean, you handle personal injury, which is primarily car wrecks and truck wrecks and motorcycle accidents, things like that. But you also do a significant workers' compensation practice, and both of these are really injuries. So today, let's jump into a topic of talking about pre-existing injuries. And pre-existing issues creep up a lot of times in terms of how the insurance company may try to shift the blame to the severity of what you're dealing with, and therefore save some money by not giving you such a larger award, because they're going to say, "Hey, that was already there." So let's kind of break that open and talk about when a pre-existing really is pre-existing.
Sure, and you'll see that in both the workers' comp cases and the personal injury cases, the civil type personal injury cases, car wrecks, slip and falls, truck, motorcycle accidents, things of that nature, where it comes up, and it's handled differently between the two.
That kind of surprised me when we were prepping for this, and I didn't realize that. So let's,
yes,
yeah.
It is handled differently from the workers' compensation perspective. It's kind of broken down. Was the condition a pre-existing active condition, or was it a pre-existing dormant condition? And those are treated differently under the workers' compensation law. If it's a pre-existing dormant condition, then the work injury arouses or brings that dormant condition into disabling reality or makes it painful, then the entire condition is 100% compensable and covered by the Workers' Compensation Act in Kentucky. All the medical treatment and everything is covered.
So the premise there is, hey, it wasn't bothering you beforehand. You had this accident or this injury, and now it's exacerbated. It's gotten worse. So, yeah, all of this can be tracked back to that most recent injury.
Exactly. And if you, at least what doctors have told me over the years is, if you take a 55-year-old male or female, it doesn't make any difference, a 55-year-old person, and you do an MRI of their back, you're going to see some changes, arthritic changes, whatever you want to call it, degenerative changes, usually degenerative disc disease and things of that nature that are going to be there, that for most people is not problematic, but it can become problematic if you suffer an injury, and that can cause the condition to be painful, cause some bulging disc, some potential pinching of nerves or impingement of nerves that can take place, that can cause problems for the individual long-term, cause significant medical treatment. And if that's the case, if it wasn't, if they'd never had problems before with the condition, then, that doesn't matter. The fact that they had this pre-existing degenerative condition that was not painful, was not causing any medical treatment, any work restrictions, and then they have this injury, then the injury, the work injury is considered to be the cause of all of the problems in that setting.
So again, under this scenario, that would be classified as a dormant condition, correct?
Correct.
Okay, we're in the workers' comp arena here, so that's dormant. But now, what happens if it's active? How would you define that, and how does that make a difference?
The terms are defined differently in the legal field and in the medical field.
That's got to make it interesting.
It does, because I've cross-examined several defense-oriented doctors or doctors hired by the insurance companies in these cases where they would say the condition was an active condition, and by that they just mean that it was present, that the person had degenerative disc disease, and you have to go through with them and say, okay, but he had degenerative disc disease, but that was there before the injury, but was it causing him any problems? No, it wasn't causing him any problems. And is what caused it to start causing problems the work injury? Yes, that's what caused it. So you have to kind of step them through the legal definition of it from that standpoint. And the difference between the dormant and the active from a legal standpoint is not, is it present? Active from the legal standpoint, for it to be considered active in Kentucky, is that it was symptomatic. In other words, you were having some symptoms from the condition. The case law says immediately before the work injury. Doesn't really mean immediately before the work injury. If you had, you didn't have pain the day before the work injury, but you had pain a month before the work injury that's very similar, that's going to be considered an active condition.
It's not like you experienced a spasm and that's what caused the accident. That's not what we're talking about.
Right. And so it has to be symptomatic and also impairment rateable. And unless you've been involved in workers' compensation cases, you have absolutely no idea what impairment rateable means. But impairment rateable means that it qualified for an impairment rating under the AMA Guides to Impairment. Kentucky uses the 5th edition of that book. And that basically just says if you have this condition with these symptoms or these complications or these diagnostic tests, this diagnostic positive findings, then you have a certain percentage impairment rating, which means your body has been impaired or anatomically changed by a percentage. And it will vary based on body part, what kind of problem you have and things of that nature.
So maybe I don't have full range of motion in the shoulder, so I can't really raise up as high as I used to, things like that.
Exactly. That would provide for an impairment rating. If you've had a low back surgery, that's going to be an impairment
Some kind
rating.
of fusion or something like that with your vertebrae.
Yes, exactly. Those type of things will be an impairment rating. Even a prior lumbar strain can certainly cause an impairment rating if it has some other complicating factors to it, or it lasts for a decent period of time. So that in Kentucky requires for prior active impairment, it's the insurance company that's bringing that up in a workers' compensation claim and saying part of this condition was active before this injury. So Kentucky puts the burden on the insurance company or the employer and the defense attorney to actually establish that issue. So they're the ones who have the burden of proving that the condition was prior active, which is different than normal, because normally every issue in a workers' compensation case, the burden of proof is on the person bringing the claim. And that's about the only one I can think of that the defendant has the burden of proof on in a workers' compensation case.
So the employer's attorneys may say, well, were you on medication for this pain? Were you experiencing this? Did you have these restrictions or something like that? And that may establish that it was active?
Correct.
Okay.
Yeah, they will ask the questions to establish that it was symptomatic beforehand. And if you had medical treatment, they will file those before the work injury. They will file those medical records into evidence. And most of the time, they will have you evaluated by a doctor that they've handpicked to do the evaluation. And one of the things they're asking that doctor to do is to address whether the condition would have been would have provided for an impairment rating even before the work injury occurred. And if they don't do that, then even if it was symptomatic, if they can't prove that it's impairment rateable, there's not a carve out in that setting.
Okay, and what exactly is a carve out? What is that? Is that where they kind of say, well, we're gonna blame part of it on the pre-existing, but there's more over here?
It is, and it basically is just a subtraction. Excuse me.
I have trouble with math too.
Yeah, there's a reason I become a lawyer instead of an accountant. But yeah, you just subtract it out. So if the person, there's a couple ways to deal with it, but if the person has now a 15% impairment rating and they had a 5% impairment rating before the work injury, then the 15% is reduced by 5% and brings it down to 10% that is compensable
for this occurrence
for the work injury from that setting. Now, there are some other ways to deal with it. And if the work injury would have caused the entirety of the impairment rating in and of itself, then there should not be a carve out from that standpoint. So if a person had a lumbar strain that may have been a 5%, but then they have a work injury where they fracture two vertebrae in their lower back and have to have a fusion surgery for that causes a 20% impairment rating. The 20% impairment rating would have been there regardless of the fact that they'd had a previous lumbar strain. It was because they had this fracture, these fractures that resulted in fusion of the spine. And so in that situation, at least in my opinion, and I think Kentucky law is that there should not be a carve out because a work injury caused all of the impairment, regardless of the fact that there had been a prior impairment rating assigned to the case.
Okay, and that's especially important coming back to the dormant scenario where, it was there, but it was really this incident that really amplified everything, made it worse, so you own the whole thing.
Correct.
You break it, you own it.
Yeah, exactly, and that's to a large extent on the dormant non-disabling kind of the philosophy behind that is that it's if you break it, you buy it, and if the work injury is what causes the disability, then it caused 100% of the disability. The person had nothing going on beforehand. After the work injury, they got all of these problems. Then all of those problems are compensable if the person, if they had a prior injury, they were working under restrictions. Had an impairment rating, were still having ongoing pain, but then after the work injury, the pain has increased. They have greater restrictions. They have a greater impairment rating. Well, the work injury is not the reason for all of the disability the person has, so the employer is not responsible for all of the disability the person has.
And so at that point, you've got a carve out of some sort.
Exactly.
Okay, so I'm going to get technical here from a workers' compensation language standpoint. So let's assume I've had a previous injury on the job and I've got some kind of impairment rating. Let's say it's 5%, okay? And maybe at that point, I've got permanent partial disability. So I'm getting a little bit of compensation for that 5% disability, okay, or impairment rating. Now I have a second injury, and so now I've got on top of that another 20%. Am I going to get, if you prevail in the case, in the claim, am I going to get my original 5 plus the 20, so I've actually got 2, or does one supersede the other altogether? Does that make sense?
It does make sense. And one thing I haven't mentioned that I need to point out is that for a prior active rating to be carved out or prior active disability to be carved out, it's got to be to the same body part.
Okay.
So if you've had a 5% from a lumbar injury, a low back injury, and then you have a neck injury, that causes a 20%, you're going to get another 20%.
Okay.
If you have an injury that causes a 20% to the low back, then there is, and the 20% is combination of the old injury and the new injury.
So the 5 plus now 15.
Yeah. Then there would be a carve out in that setting to where you would get compensated for 15% instead of the.
But would I still get 20%. My original 5?
If the workers' comp benefits for partial disability, which is what we're talking about here, not total disability, is paid out over a period of time or sometimes paid in a lump sum.
Right.
So if it's paid in a lump sum, you've already gotten all the compensation. If it's paid out over a period of 8 years, or 425 weeks is what the law says, or 520 depending on the impairment rating. But for 5%, it'd be 425 weeks. So if you're in week 200, then yes, you'd get both there. If you're past 400
until that runs,
until the 425 from the first one runs.
Okay.
If you're already past the 425 weeks, that check is already stopped. Then obviously they don't overlap at that point.
Okay. Friends, if you're listening to this, and this sounds a little complicated, maybe this is one of the first episodes you've actually listened to, when you look at your screen, wherever you're listening to this podcast, there's usually going to be a set of paragraphs below each of the episodes where you're actually hitting play and it's going on. Those are called show notes or episode notes. And in there, I'm going to put some links to some previous episodes, so you'll be able to go back and see. Here's Jeff talking really more in depth about an impairment rating. So if you're still trying to figure out really what that is, you'll have that. And when we start talking about permanent partial disability things, again, I'll put a link in there so that you can have a reference point there. at the end of the day, Jeff, and I've said this in previous episodes, this stuff is complicated. And it's a good reason to get a qualified attorney who's got your level of experience, because you're going to be able to understand this and explain this really easily when somebody's sitting down with you to understand how that rolls out. So again, from an audience standpoint, if it's complicated, there's information there in the show notes. But again, call Jeff. I think that's the easiest. That's the easiest point.
Yeah, it is complicated, and it's workers' comp is an area of law that is to a large extent very different than pretty much everything else because of the way it's handled, and it's kind of a practice unto itself to some extent. If you when you break into workers' comp, start doing workers' compensation cases, from an attorney perspective, you need to have an attorney who knows workers' compensation and to kind of mentor you from that. I had the benefit of that in my career when I first started practicing. The attorney I started practicing with had handled workers' comp for numerous years beforehand and was a great mentor to me from that perspective. And it's just not an area that is well suited for someone trying to handle a case pro se. There's really no area of the law that's well suited for someone to handle pro se. But workers
pro se just means on their own, right?
Yes, on your own without an attorney. Yeah. But workers' comp, there are so many different pitfalls that you can fall into without even realizing it. That can basically completely kick your case out and lose not only the disability benefits, but lose potentially lifetime medical treatment for the work injury. So I mean, you can be your finances can be majorly affected, not only in money coming in because of the disability you would receive, but on what you're having to pay out of pocket as well for future medical care. So having an attorney like myself who has a lot of experience handling workers' compensation cases, and that's something you need to ask because there are attorneys who advertise for areas that they don't really practice a great deal of, and maybe refer them out to people, and that's fine to do that. But you should, when you're first meeting with the attorney or you're talking to them about a meeting with the attorney, find out how much experience the attorney has in handling the workers' compensation claim. And frankly, I think you should do that. I don't do divorces, but you should do that in a divorce case. You should do that in pretty much any legal field, find out, or legal issue, find out the experience the person has handling that type of claim to make sure you're getting someone who is very familiar with that area of law and can do you the best job possible. And call me up. The initial consultation's free. I am actually coming very close to finishing my 29th year of practicing law, probably about a week or so. I know it was late October of 1992 when I was sworn in to practice. I can't remember the exact date now, but so I've got a lot of experience doing workers' compensation cases, and having someone that knows that is you're going to be better off in the long run than you are having someone who doesn't know what they're doing or trying to do it yourself.
Well, and it's kind of interesting because a lot of firms out there may handle injuries, so they may do car wrecks or dog bites and things like that. But when it comes to workers' comp and another area that you have significant experience in, Social Security disability, they don't really get into those as much, so they may refer those out as well. But you're kind of one of the things I like about your practice is that you handle all three of those, and obviously all three of those are injury related. Right,
I do handle all three of those, and occasionally it's not real common, but occasionally I have a case where all three are interrelated in one case. A person has a car wreck while on the job, and it becomes totally disabling. And they weren't at fault in causing the wreck. They've got a personal injury claim against the at-fault driver. They got a workers' compensation claim because they were on the job, and now because they're totally disabled, they got a Social Security disability claim. In having one handle all three of those is less costly, and you've got somebody who is making sure they're coordinating all of the cases to have the best recovery for you that you can possibly have in that setting. So that is good from doing it from that perspective. And we've talked about the prior active or pre-existing conditions from the workers' comp perspective. We haven't talked about it from the personal injury perspective, and it's treated differently. They're basically under the personal injury side, whether it's a motorcycle wreck, a semi-truck wreck, car wreck, slip and fall. They're all going to be treated the same in regard to that, and it is what did that injury, how much did it aggravate the pre-existing condition? You're entitled to compensation for the aggravation of the pre-existing condition. So they're all going to be addressed there, and it's not as much of a prior active or prior dormant. Now, that certainly comes in play because if it's dormant, the aggravation is obviously much greater and arguably 100% the cause of the condition from that than if it's a prior act, than if it's something that was symptomatic and being treated beforehand. But you're looking at having to establish that this condition or this injury aggravated the pre-existing problem, and how did it aggravate it, and how did it make it worse? Did it cause the medical treatment? Would the medical treatment occurred anyway? Did it hasten it so that it's going to occur much quicker and much more extensive type things? And so there's a different process for those cases in what you have to establish and prove to get the client the proper compensation.
And again, it's fairly obvious, but I want you to explain it if you would. Why does the insurance carrier, again, working for the at-fault driver or working for the company, the defense attorney, if you will, why do they want to prove a pre-existing situation existed?
To reduce the amount of money that the injured person will receive.
It's really that simple, isn't it?
It is that simple. I mean, if they can, in both perspectives, if they can prove it was pre-existing active and there should be a carve-out in the workers' compensation claim, that reduces how much they have to pay out to that injured person, and they get to keep that in their bank account instead of paying it out. And the same in the personal injury side of it, if they can establish that this aggravated the pre-existing condition 50%, then at least the proper role for the jury is if they think it's 50% is total damages or this, the aggravation caused 50% of those damages, so it should be reduced by 50%.
It's just math at that point, right?
Yeah, it is, and their goal is to basically reduce what they have to pay out in funds to the injured party, and once the injury occurs, and frankly, the different carriers will tell you that they don't do that. But in my opinion, once the injury occurs and the insurance companies find out about the injury, their primary goal is to, how can we pay as little out as possible in this claim? And they will do an investigation to try to establish there is a pre-existing condition or you were at fault in causing this, etc. And it's the entire thing is, so at the end we're paying this person less money than we would have otherwise. And my goal is to make sure my client is getting the most money, getting fair compensation for their injuries and getting compensated for all of their injuries that they received.
In coming back to that statement you made earlier about representing yourself and really why you probably shouldn't do that, you handle these types of cases on a day-to-day, basis. I mean, you've got almost 29, 30 years now of handling these cases. You know it inside and out. And the defense attorneys, the insurance team on the other side, they've also done it every day, day in and day out. And when you walk into that arena by yourself, you're a little outmatched. I mean, whether you want to admit it or not.
Yeah, exactly. You are. And
Not to mention just the legal environment, which is going to have its own twists and turns.
Right. And, there are deadlines, and we've talked about this before, but there are deadlines on doing things. And the insurance company knows what those deadlines are, and most individuals have no idea what those deadlines are. So if you wait too long to file a workers' compensation claim, then you're barred from pursuing the workers' compensation claim. And there a lot. And I've talked to people, unfortunately, and told them, and unfortunately, we're past the deadline for filing this.
And that's that statute of limitation.
Statute of limitations, and I've had the conversation more times than I wish I had of, where the workers' comp carrier continued to pay the medical, and they thought, well, they're still paying the medical. They told me they've accepted this claim, and they think they're fine from that. And then once that statute of limitations expires, the insurance company stops paying the medical and sends a letter saying, statute of limitations expired. We don't owe you anything anymore.
We're off the hook.
Exactly, we're off the hook at that point. And then they go see an attorney at that time and find out, unfortunately, that they're too late to pursue anything, that the statute of limitations has expired. Occasionally, there's a way around it, but it's those cases where there's a way around that statute of limitations are few and far between. From there, and the same with a car wreck or motorcycle wreck, truck wreck type situation, there is a deadline that you have to have within which to file it, and if you let that pass, then you've lost that claim.
Right. And that's, we've talked about I keep saying we've talked about it before, but we actually have, in that, a lot of us show up and we're ready to go to work and we want to do the best job we can for our employer, and we expect our employer to kind of have our back and to work with us, and in many cases they do. But when there's an injury, sometimes that relationship changes very, very subtly, or very, very quickly, and you're like, what happened? These guys used to be on my side. Now they're fighting against me. Well, yeah, there's money involved.
Well, that is true.
It's unfortunate, but I mean, that's...
Yes, and some employers tend to take it personal for some reason. When, frankly, if you ask them, if somebody... if the employee in the parking lot backed into the employer's truck and did damage to the truck, they wouldn't think that it was personal for them to have that employee's car insurance pay for the damage to their truck, but somehow it's a personal matter when the injured worker has physical injury to themselves, and it's personal when they have the workers' comp insurance pay for that. It doesn't make sense to me, but that's just the way it is for some individuals. And to me, a physical injury is much worse than property damage is. But
right. With longer lasting, issues.
Longer lasting, but I've talked to a lot of people who have no problem with getting their property damage paid, but then they have a problem with somebody getting their physical injuries paid for. And it's just a different mindset between mine, I guess. But as far as a lot of these things, the employer has no idea what's going on either. Once the case gets sent to the insurance company, the employer is really out of the loop. Now, there are some that stay in the loop because they may be self-insured for workers' comp, or it's just a company that likes to stay kind of informed on what's going on. But most of the time, they don't know, and they can't tell their injured worker what the statute of limitations is in the workers' compensation claim because they have no more knowledge of it than the employee does.
Well, and unfortunately, some of them may not want to tell them.
Yes. Yeah. Insurance companies definitely don't want to tell them, but a lot of times the employers aren't going to know that either. From that now, but there are some employers, and most employers really, they understand somebody gets hurt, they need to get treated and get better, and they don't take it personal, don't have any problems with it. And in fact, I've actually had some employers, when they thought their injured worker was getting the runaround from the insurance company, have told them to come see me and don't worry about pursuing the workers' comp claim. Go see them and do it because you need to be taken care of. So there are some employers that are that way, and frankly, I would hope that I would be that type of employer,
right.
And I think it would be that type of employer, and I wish more were like that.
Right. And Jeff, as we close up this episode, one thing I would probably like to get from you is if I've been injured and I knew I had a pre-existing situation, I should really be open and honest with you as my attorney, right? I mean, there's not an advantage to trying to conceal that or hide that from me, right?
Absolutely should be open and honest about that. In fact, if you tell me about it, we can deal with it. I can explore it, find out what it is, explain to you what's going on and how that's going to affect the case. If you hide it from me, I can tell you that the insurance company is going to find out about it. They're going to get all the records, and a lot of insurance companies will look for records from, even if you don't tell them that you've been, there's only one hospital in Murray. And so if you've been to Murray Calloway County Hospital for low back injury from cutting wood at your house or whatever, they're going to get that record. Even if you don't include that you've ever been to Murray Calloway County Hospital, they're going to get all of those records from Murray Calloway County Hospital. They're going to find that. And then that's going to come back and bite you a lot worse than if you'd been upfront and honest about it. And if I know about it, I can deal with it, and I can lessen the impact on it to some extent, or at least prepare you for what the impact is going to be, and make sure our doctors address that. The treating doctors, or if I have an evaluating doctor, my evaluating doctor addresses those issues. If I don't, then the insurance company's doctors are the only ones who know about it, the only ones who are addressing it, and we get caught by surprise.
That's never a good thing.
It's never a good thing in the legal field, and it's happened before.
Yeah.
And I've had cases where really, where it's made a big difference in the case. And I told the client then, I said, this would have had a whole lot less impact if we had known about this 6 months ago than finding out about it now. And it's just, I just be honest with your attorney. What you tell your attorney is confidential attorney-client communication. So if it's something that you don't want out there now, as far as medical records, things like that, I've got to share those in cases. But don't worry that you're going to tell him something that's going to hurt your case. You not telling him is going to hurt your case a lot worse than telling him.
Right. And so, Jeff...
Or her.
Right. Yeah. So, Jeff, if I've been injured at work, or maybe I've been in a car accident and I need somebody that understands how to deal with these pre-existing situations, what's the best way for me to get in touch with you?
Best way is to call my office, 270-753-0053. If you're out of the area and want to use the 800 number, 1-800-844-5108, that's the best way to get in touch with me. My wife will tell you that I'm here at the office much more than I'm at home. But you can also email me at jeff@jeffrobertslaw.com if you, as well. But calling up, the initial consultation is free. If you're outside the area and don't want to drive in, we can do the initial consultation over the phone. If you want to come in, we can do the initial consultation here in my office. From that, I prefer in-office appointments just because I can read, a large portion of communication is nonverbal. And if you're in the office, I can see that. And if I see that I'm being too technical or losing you, I can rephrase things to make sure you're understanding everything.
Well, because it's complicated things that you need to know and that you're going to be explaining. It's not that the general public can't understand it, but you need to be sure. You've got a responsibility to make sure that your client does fully understand what's going on here, because you're working in their best interest.
Exactly. And, I try not to speak in legal speak, but sometimes I do. I'm trained to do that to some extent. So
It's your wheelhouse.
Yeah, when I'm talking to other lawyers, I do it all the time. When I'm talking to clients, I try not to do that. But sometimes I do it without realizing I have, and I may use the phrase temporary total disability, which I know, and all of my staff knows what that means. My client may not know what that means, and I've got to go back and say, well, that's the workers' comp benefit you get when you're off work under doctor's orders, and then they know what I'm talking about at that point. And so, it's just, unfortunately, we've become a creature of habit, and sometimes those things slip out. And if you're in the office, I can see the look on your face when I say that, and then I back up and say, okay, this is what that means, so that you're understanding exactly what that is. And it's not anything to do with intelligence. If I talk to, and I've had this where I've talked to semi-truck drivers, and they start talking about
technical aspects of something.
They start talking about things that, pulling a kingpin and adjusting tandems, etc. That if they're talking to another semi-truck driver, knows exactly what they're talking about, and I've got to go back. Hold on, now. First couple of times when they said that, what is that, and what do you mean by that? For them to explain to me what it is, and that's the same with any other field. If I'm not familiar with that field, I'm not going to know that terminology. If you're not familiar with the legal field, you're not going to know the terminology here either.
Well, I think even in some of the Google reviews that your firm's actually received, which you can see online there, people talk about how you really make people feel at ease. You make them feel comfortable. And I think anytime you're engaging with an attorney, that comfort level is very, very important. And I've seen comments that your entire staff is really, really focused on that. And I think, again, that's just a credit to how you've kind of built your business here.
Well, I appreciate that, and I appreciate it when the clients say that in the reviews. I appreciate more that that's the way they feel.
Yeah.
When we are representing them. I have the slogan that we use, but it's the slogan I use because it's the way I do actually try to practice, and that is I try to give small town service and deliver big city results. And when you're in my office, you're not a number. You're not getting shipped. I've got paralegals, don't get me wrong, but you're not getting shipped off to an associate attorney. I'm the one handling your case. And I tried to treat, I tried to follow the golden rule and treat people like I would want to be treated. And if I had a legal issue that I was dealing with an attorney on, I would want them to keep me informed, keep me updated, and to talk with me in ways that I understand what's going on, and treat me with the respect that I should be the one making the decision on my case. You give me the information I need. You tell me what you recommend. Let me make the ultimate decision and keep me informed of what's taking place. And when you do that, you tend to have satisfied clients at the end of the representation.
Well, I tell you, anybody that reads through those Google reviews is going to see you've got a few. You've got more than a few.
Yeah.
So again, congratulations. Well, Jeff, that's a good way to go ahead and wrap up this episode. And I appreciate your time. And friends, if you've been listening to this episode, I want to thank you again for your time. I know there's a lot of stuff you could be doing in a day-to-day basis, but for some reason you sat down and you decided to listen to this podcast about Jeff Roberts and the law firm right here down in Murray, Kentucky, the Roberts Law Office. So once again, we'll be back in a couple of weeks, and we thank you for listening.
Thank you.
Absolutely. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.